Good morning, ladies and gentlemen, and welcome to today's webinar on the SEC Cybersecurity Disclosure Rules. I know most of you will have been expecting to be hearing from William Gamble, who is a senior lawyer on our team. He unfortunately is not able to be here today, so I have stepped into the breach, so to speak. While I don't have William's depth of experience, I do have quite a lot of knowledge of how to go about meeting the compliance requirements of, for instance, the SEC cybersecurity rules, and we'll be working through the material that William put together for this webinar. So apart from my slightly lesser detailed knowledge of the subject, I'm hoping that you will find that you get out of this webinar pretty much exactly what you were expecting to get from it. The webinar is due to run for about 45 minutes. I'm hoping that my bit will be about 35 to 40 minutes. So we've got 5 or 10 minutes left for questions at the end. You will have noticed that you're on mute, but please, if you find that you have questions as we go through the webinar, there is in your GoToWebinar panel a section called questions. If you type questions in there, when we come to the Q&A section, I will turn to that and I will read out and share with you the questions and endeavor to answer them. My own background is some 25 years in cybersecurity and privacy and in compliance generally. I wrote a book which is the Open University textbook for cybersecurity. I've written a number of other books around information security, around privacy, around cyber resilience and cybersecurity and so on. And I've done an awful lot of consulting, but mostly I set up IT governance as a company some 20 odd years ago. And in those 20 years, we've grown as cybersecurity has moved from being an optional issue to being a compliance requirement to some 200 people. We operate across all 5 continents. We've done work with some 12,000 clients on their ISO 27001 cybersecurity and compliance challenges, and our IT governance, risk and compliance solutions are very widely used indeed. 1,300 organizations we've helped get to ISO 27001, the international cybersecurity standard. We've delivered some 1,600 cybersecurity projects, helped 7,000 clients achieve the UK Cyber Essentials certification, and we have some 1,100 organizations using some or other part of our governance, risk management and compliance platform, Cyber Comply. Our agenda for today is an overview of SEC's rules. They're no longer, of course, proposed. It is the rule. A look at some more detail at the requirements of the new rules, the compliance deadlines for listed companies, and then how the Cyber Comply platform can be leveraged to simplify the business of complying with those rules, and then a brief look at some of the compliance solutions which we can make available with, as I said, a Q&A section at the end for me to answer any questions that you may have. So that's the agenda. Let's start with an overview of the rules and their significance. And a good place to start is why? Why are the new rules in place? And if you stand back from the rules, the reality is that the threat horizon has become more and more crowded. The range of ways in which cyber criminals can attack organization has become more prolific. There are new ways of mounting attacks being developed every day. Southeast Asia is ground zero for cyber attacks. They're developing new ways of attacking organizations and individuals which still haven't yet made their way into the Americas. But it's a very crowded and increasingly crowded threat horizon. At the same time, the attack perimeter has the attack surface, the secure perimeter of the organization has gone on expanding. And so whereas 15 or 20 years ago, when computers were still kind of new from a business point of view, I mean, kind of, they were much more widely used, but the perimeter was basically server and device architecture, limited number of endpoints. You could wall everything off. You could be very secure. In the last 20 years, we've seen a massive explosion of ways in which attackers can get into networks. So, on the one hand, there's the proliferation of devices, mobile devices, Internet of Things, and so on. On the other hand, there is social media, there is remote and hybrid working, there is migration to cloud. All of those things mean that there are more and more ways in which attackers can get in because of the speed at which organizations are deploying in that environment. Of course, the level of security is not necessarily what it used to be when expansion was happening slowly and you could have it completely under control. So the opportunity for attack is terrific. But the answer, of course, isn't to deploy more technology to deal with it, because the real problem that you have in this kind of environment is us, is human beings. And the reality is you can spend millions of dollars on firewalls, on anti-malware software, on compartmentalization, on all of the kinds of things that organizations and CISOs do, and you're still going to be in trouble because we employ human beings, and human beings are prone to make errors, and the making of those errors is what increasingly cyber attackers focus on. They focus on how can they engineer an attack so somebody will click on something and download it. And the proliferation of successful attacks is huge, and that's before AI and deepfakes have become a fundamental part of the way in which cyber attackers go about doing their business. So the new rules come into existence because the reality for most investors is that they find themselves investing in companies which have a major cyber breach. And of course, a major cyber breach leads to loss of money by the organization, loss of clients, loss of reputation, which affects the value of the holding. And from the perspective, therefore, of the SEC, set of regulations which is designed to improve the robustness of listed organizations is a fundamental step taking place in the context of the wider push across the whole of the United States to improve cybersecurity, which we've seen in the current regulations and new departments dealing with cybersecurity in the federal infrastructure and across a number of separate sectors. So we're operating in an environment in which regulators are increasingly focused on making sure that cybersecurity is something which organizations can do and do. And that's the context in which to look at the SEC disclosure rules. What they're essentially saying is that simply deploying technology is no longer enough. What organizations have to do at board and senior management level is put in place processes that will ensure that there are appropriate governance frameworks, appropriate risk management, appropriate processes around dealing with incidents as and when they happen, because incidents will happen. There's no such thing as incident-free life in today's world, and therefore making sure incidents are appropriately disclosed in a way that enables organizations to be transparent and for investors and financial institutions to understand what's really happening. So what the rules do is they standardize disclosure requirements for public companies, for investors and market participants, and there are two main components to that. The first is a requirement to annually disclose how you go about doing cybersecurity risk management, what your strategy and governance framework looks like. And the second is that you disclose material cybersecurity incidents. Yep, you've got to tag them in inline XBRL, but that's in a sense a technical issue. The real issue is that you've got to put in place, if you don't already have it, a set of governance frameworks and strategies and an incident management reporting process which enables you to demonstrate that you're compliant with the requirements. The rules affect all domestic registrants and foreign private issuers subject to the SEA's reporting requirements, and also to business development companies. So it's pretty broad. If you're listed, it applies to you, and practically speaking, it's going to apply through you to any supplier on whom you have a significant dependency, because the nature of the supply chain, the extent to which you have single points of failure inside your supply chain can mean that your own service is disrupted. And so it's worthwhile thinking about SEC compliance requirement in much the same way as you think about SOX compliance. If this is an entity on which a significant proportion of your internal control environment or your significant proportion of your service delivery depends, then you're going to want to look at them and expect from them a level of compliance which enables you in your own disclosures to demonstrate that you are compliant. And the key changes that come into place as a result of the rules, and I've highlighted them. So I've given you the kind of basic legal requirements that item 106 has added its regulation SK and got to turn up on the annual 10K report. But the requirement is around cybersecurity risk management, strategy, and governance. You've got to disclose basically what you're doing about that. And that means that because you're disclosing it, you need to have something in place. So anything that's informal needs to become formal. You need to have properly documented processes. You need to have a risk assessment which is carried out in a practical way using some methodology which is demonstrably appropriate, carried out by people who are demonstrably competent to do what you've asked them to do. So you've got to have in place and disclose your cybersecurity risk management processes, what your strategy is around cybersecurity. Strategy is, what are we going to do about technology deployments, about business developments, about acquisitions? How are we going to handle cybersecurity risk in all of those environments? What's our strategy around the human error? What's our strategy around suppliers? What's our strategy around upcoming cyber risk? What's sitting on the risk horizon? And that leads into the requirement that you describe your processes for assessing, identifying, and managing material risks from cybersecurity threats. So material, usefully not specifically defined in terms that everybody can deal with. You've got to define what material is in a way that makes sense to your organization. So risk appetite, it's a fundamental part of cybersecurity risk assessment. A key element of what boards have to do is set out clearly what their risk appetite is in a way that enables management and functional experts to do their jobs properly. And you measure risk appetite in terms of the criteria like the ability of the organization to absorb loss, the level of cybersecurity insurance that you might have. There are a number of different criteria that you can have, but you need to be able to determine what risk appetite is, and therefore you can set out what you think a material risk is. And this is something which is important to get right now, not when you've got a risk and you're busy going, ooh, is this material, do we need to disclose it or not? Because you're already in trouble at that point. If you know what a material risk looks like, you can build a risk response process to deal with it. And then once you've dealt with it in accordance with the way you planned, you can report what you did, how you did it, and you will be compliant. Of course, if you've had previous cybersecurity incidents, you've got to talk about how they might reasonably affect you in future, and that's kind of important because cyber criminals, they like to go back to the same place 2, 3, 4, 5 times because they know it takes their targets quite a long time to not only recover, but to build the cybersecurity infrastructure that wasn't there in the first place. So they'll go back and they'll hit it again. They know that in many instances, managements will try and hide the fact they've been breached. So again, good opportunity to go and have another go. So you've got to identify that. You've got to be clear about how that might materially affect you. How does the board supervise risk? Not just what does management do, but how does board supervise it? That's part of the governance framework. So key changes that you've got to think about, put in place. How do you make sure that board or board subcommittee on a regular basis is reviewing changes in threat horizon, changes in the attack surface, and is managing risk? So the material cybersecurity incident disclosure requirement, that's a pretty fundamental issue. You used to be able to kind of disclose them when you thought you might have to, but now that option doesn't exist. You have to disclose a requirement within 4 business days after determining that it's material. And you can't spend 4 business days thinking about what your criteria are as to whether or not it's material. You need to have decided that now. You need to have a very clear documentation of what material is, so that the 4 days you've got to think about whether you're disclosing it or not are the 4 days where you're busy assessing whether the the breach meets the criteria or not. You might be necessarily talking to the Attorney General in terms of national security or public safety if there is a rollover impact to that. And you're dealing with it. You know, the first 3 or 4 days you don't necessarily want to be public because you might be able to contain it, but that's all you've got. So you need to be really, really clear. Now is the time. Risk appetite, determine what your risk appetite is in measurable, objective criteria. From that, move to therefore determining what a material breach looks like. Make sure that that's the starting point for how you build your cyber incident response processes. It's key to how your strategy evolves and how you monitor what's happening in terms of cybersecurity. Before this, the rule, and so it kind of follows through, it was unlawful for anybody to in any way employ any device, scheme, or artifice to defraud, make an untrue statement of material fact, admit to state a material fact, engage in any act that would operate as a fraud or deceit in connection with the purchase or sale of any security. So before the SEC rule came in, what you already had was the legal situation that effectively not disclosing or failing to disclose or deliberately covering up a breach would have been unlawful. The regulation goes a step on from that, but it shouldn't be a shock. The requirements of the regulation are not a huge divergence from something which was already in place. The recognition that if something had happened to the organization which might lead to an impact on the value of the stock, then actually that should be disclosed. As I said, material is not defined, but usefully it is what any reasonable person would recognize as relevant to a decision to be made. So if it's material, you've got to think about what kind of looks like reasonable, which goes back to the criteria that I knew about. And there are questions you can ask yourself. You can say to yourself, is this the kind of thing which, if an investor or a buyer had known about, that you had weak cybersecurity in these ways, would they have bought the stock? If the answer is probably not, then that's material. So failure to disclose it or withhold it can operate as a fraud or deceit, and therefore you can find yourself exactly where you don't want to be. And organizations had exactly that happen to them. So Blackboard, $3 million for making misleading disclosures about a ransomware attack back in 2020. Yahoo fined $35 million for failing to disclose one of the world's largest data breaches, in which hundreds of millions of user account data was stolen. SolarWinds presently being litigated, the company and CISO charged with common law fraud. So, you know, that's under the pre-SEC regulations. The first American financial corporation fined $487,000 because it failed to maintain disclosure controls designed to ensure that all available information concerning a vulnerability was analyzed for disclosure in the public. The company's reports, Pearson, a big publisher, fined $1 million because it failed to patch a critical vulnerability and had inadequate disclosure controls and procedures. And that's all basically failures of governance, failures of management, of boards and management, in creating a framework in which these kinds of issues are reported right the way up and are reported alongside the what are we doing about it in a way that enables the board and management to verify that what they're being told is being carried out. And a proper governance framework would include the board being able to verify what is happening. So as I said, pre-rule guidance very clearly, need for cybersecurity risk factor disclosure, potential costs that might be associated, materiality of incidents and risks, disclosure of pending legal proceedings, and description of the nature of the board's role in overseeing the management of such risks. So that's the background. What do the rules actually require? Number one, disclose how the firm assesses, identifies, and manages material risk, how risk management has been integrated into the overall approach to risk management. Pretty fundamental. This is our governance framework. This is how we go about doing risk assessment. We identify risks by asset or by class or by situation. We use ISO 27005, or we use one of the NIST frameworks, but we have a very clear objective method for identifying, assessing the significance of, and managing material risks, material cyber risks to the organization. We've integrated that into our broader enterprise risk management processes. It's part of how we deal with operational, business conduct, all the other risks. Cyber risk is an integrated part of how we manage risks. Where we have relevant assessors, consultant, auditors, other third parties, we disclose those engagements, and we are very clear about how we oversee cybersecurity with third-party service providers. Remember, I said at the beginning, what's happening in your supply chain is critical, and many of your key providers, key supporters, particularly software providers, as you see with SolarWinds, they need to be clear, and you need to be clear with them about how they secure themselves and how they manage cybersecurity. So very specific requirements of Rule 106. Go on from that, disclose how the board exercises oversight. Is there a separate board committee or subcommittee? But you need to be clear about how you exercise the oversight. So means the board needs to have a working understanding of cybersecurity. Be very clear not just about how you oversee cyber risk, but who is responsible for assessing the risk and what is their expertise. And an expertise that it says, you know, this person's been doing it a long time isn't necessarily something that as a board you should rely on. You should be saying experience is a very good thing, but you want to know that somebody has a set of skills and competence that give you a reproducible risk assessment. So you've got to allow for the fact that whoever does your risk assessment might suddenly not be available, might get run over by a bus, might go on holiday, and you need to review the risk assessment. Having a risk assessment which somebody's built in their own spreadsheet and you don't know how it works is really not where you need to be. That's a very clear single point of failure. So you need somebody who goes, we use a standard known method of assessing risk. We use a tool that many people can be trained on that puts management in a position that it can always manage, review, and deal with cyber risk. How do you manage cybersecurity incidents? It's rule one with cybersecurity incidents is the time at which you want to be testing your plan is not in a real environment. You test your plans well in advance of anything happening, so that when all of the incidents that you can think of might happen do happen, you're simply rolling out a tried and tested plan. So disclose your processes for how you monitor and mitigate them, disclose how you report them to the board, and disclose any cybersecurity incidents. Very specific rule requirements. In SK, item SK, you've got to describe your processes, if any, for the assessment, identification, management of material risks from cybersecurity threats. And of course, if any means that doesn't mean you have to have any, but imagine what happens when you have a breach and you go, well, we haven't disclosed any because we didn't have any. And we haven't disclosed we didn't have any, so please don't sue us for fraud on account of everybody thought that we were secure when we're not. So the sensible commercial approach is that you build, you ignore the, if any opt-outs, and you build the processes and you disclose them as part of your overall risk management process. You monitor third-party risks, you disclose to the minimum that you can do that, but you disclose exactly what you do, and you make sure that what sits behind the scenes is a thorough and comprehensive set of processes which ensure you govern and manage those risks properly. You must, in SK item 106C, describe your oversight of risks from cybersecurity threats. You must describe the role in assessing and managing material risks. Must therefore determine expertise of the positions responsible for managing risks, and all of that. You know, you want to be able to say we have a documented process. It sets out exactly how this does. It ensures X, Y, and Z happens, and that's a very clear disclosure. Whenever a cybersecurity incident happens, you need to disclose it. You can't disclose it annually. You've got to disclose it within 4 business days of determining the incident was material. So a 1.05 Form 8K filed within 4 business days. You can delay filing if the Attorney General so determines, and if once you've put together the form, you find that some information that is called for wasn't determined or was unavailable, you can amend the form, but you've really got to have in place a process which enables you to know how you're going to make that determination in time when you have to. And remember that when you're dealing with a cybersecurity breach, you're typically overwhelmed. You typically don't have the depth of resources you need to handle the scale of the cyber breach. So it's not the point at which you want to work out how to meet the requirements of the disclosures. You want to have worked it out beforehand. You need a robust process that enables you to deal with it, and you want that sitting alongside the robust processes you've worked out and developed for dealing with cyber incidents. Same set of rules basically applies to foreign private issuers. They've got to disclose material cybersecurity incidents, describe board's oversight of risks, and describe management's role in assessing and managing material risks. So broadly speaking, foreign private issuers subject to exactly the same sets of requirements as normal registrants. So that's what you've got to do. You've got to create a plan. The logical way to create a plan is a management system. And you know, with all cybersecurity, with SEC regulation requirements, you want to know that you are compliant, so you need a management system which is robust. You don't want to spend a lot of money litigating and defending. It's much better to spend a small amount of money getting yourself secure upfront. So management system, something like ISO 27001 or one of the NIST special publication management systems, is a logical way to create a security program. There's a bunch of documentation which comes out of that security program, which covers governance, policy, processes, how you're going to deal with stuff. So make sure that the specific SEC rules are built into your security documentation. Then implement it. Make sure that you roll it out, you put the processes in place, you make sure that all of the things people should be doing, they know how to do. Make sure that your incident response process is tested and that you can handle incident response processes, and then make sure that you make your annual disclosures as you should do. You can simply identify that you've got the appropriate documentation in place, and you can, if you're sensible, continue improving what you're doing so that from year to year your cybersecurity processes get more robust, because that's what they need to do dealing with the increasingly sophisticated attacks that are coming at you. Compliance deadlines, well, any disclosures, the item 106 form 10K must provide any disclosures there by December the 15th. So that's just a couple of weeks away. The 1.05 8K compliance starts on December the 18th. Any XBRL disclosures must start on December the 15th for 10Ks, and 8K disclosures also in the inline XBRL just begins December the 18th. So compliance deadlines coming up right now, 2 weeks away. You want to be making as much progress as you can, because again, like I said, it's not as though any of the stuff is desperately new. The regulation has been in development for 2 years. The pre-rule requirements are not that different from what the rule puts in place. So you should be really in a good position to get on with putting this in place. The reality is many organizations won't be. And so thinking about compliance, one of the logical ways of doing that is through a platform. We see increasingly that organizations typically have to comply with between 6 and 15 different sets of regional, sector, national regulations covering cybersecurity and privacy. That's virtually impossible to do with any cybersecurity, cyber compliance team. And a platform like CyberComply is built absolutely to help do that. So CyberComply is a platform that integrates a whole set of governance, risk management, and compliance solutions: cybersecurity, information security, data privacy, incident response, business continuity, and so on, in a way that's integrated and which recognizes the combination of a platform that gives you workflows with information and training for staff, with qualifications for staff relevant, with access to professional expertise where you need it to help deploy and implement particular management system compliance requirements. So CyberComply aligns with industry best practices and standards, helps you identify and treat data security risks fast, It enables you to map data flows. It's a key part of working out what you need to do in terms of risk assessment, is knowing what data flows you've got going on, where your key risks are. And you can use then a built-in tool which works to international best practice standards to do cybersecurity risk assessment. People can be trained on it. It drives savings in time, money, and resources. And all of that takes error and mistakes out of the process. It becomes a lot more efficient, a lot more robust, and that means that you can drive through the organization out of the risk-based risk treatment plan tasks to individuals inside the organization, which enables you to monitor the extent to which people are carrying out and dealing with what they should be doing. CyberComply also has an integrated security incident investigation and management component that enables you to manage incidents, to report in the way that you want to consistently, and to have oversight of how you're managing the incidents. So sum up then, CyberComply, automated compliance for SEC disclosures. It will increasingly be able to simply produce the documentation that you need, but at the moment it gives you the documentation so that you can easily complete the forms knowing you've got exactly what you need to have. Brings your costs down, seamless integration across a whole range of privacy and cybersecurity compliance. It's versatile. It enables you to deploy ISO 27001, NIST special publication controls, CS18, PCI, whatever the controls are that you need, very straightforward to do, and manage in that environment incidents and incident response in a way that is transparent and demonstrates accountability. And all of that with a dashboard that enables boards and management to see real time how security is being managed inside the organization. So CyberComply, and when the slides go out, and so one of the questions I know a number of people have asked, the slides will be available to everybody on the webinar and will be sent out to everybody within about 48 hours. If you click through on the link, the CyberComply link, you'll be able to go straight through to have a closer look at the platform yourself. In terms of our own solutions, so there is an SEC for Board of Directors training course. There is an introductory guide on how to apply the SEC regulations. We can come and do a gap analysis for you and help you identify exactly the ways in which you are not compliant and what a route to compliance looks like. There's a set of documentation which is core risk management and government documentation that you can, that's adapted for you to be able to deploy in a way to get you very quickly to be able to demonstrate that you are compliant with the SEC requirements. And so, ladies and gentlemen, that brings me to the end of what I had been planning to say. There is now a bit of time available for questions. If you do have questions, please do put them into the questions panel in your GoToWebinar panel. If you type a question in there, if anybody has any questions, then I'll answer the questions. I'll read the question out and I'll answer the question so that everybody knows what the question and answer is. So if I give you a couple of minutes to just do that. So will the webinar recording be available as well as the slides? Yes, it will be, is the answer to that question. We'll send out a link to everybody so that you can access the recording and the slides simultaneously. Yes, indeed, the recording of the webinar. Yes, you can revisit how to determine materiality, so you're not stuck with it forever. The nature of changing business, the nature of changing threat environment, of attack surface means that boards should, I would normally recommend on at least an annual basis, revisit its risk appetite and its determination of materiality, taking account of the current state of play, of incidents that have happened, and then revise, if you think that's appropriate, what your risk treatment plan, incident response plans are on that basis. But yes, the short answer is you should, and you should plan. You should have an annually planned review of the risk appetite and definition of materiality. What is the definition of business development company and foreign private issuer? They're both standard SEC regulations. We'll send you a link separately rather than me attempting to define them for you. We'll put a link in with the slides so that you can access those SEC definitions. Do we need to follow the new SEC reporting rule in a few weeks? In a few weeks. It comes into effect from 15th and 18th, depending on which rules they are, as it says in the slide, from December 2023. So that's 2 weeks away. Quite a lot of scrambling we feel for lots of organizations to get themselves compliant. And one way to do that, of course, is to access many of the tools that we can make available, because that can save you an awful lot of time in working out how to put things in place yourself. Kind of have the feeling, ladies and gentlemen, that that might be the end of questions. It's not. What is the average estimated time to complete the requirements using the toolkit? Is a good question. It depends on the complexity of the organization and the complexity of what it is that you're doing. But typically you could complete the documentation in a matter of days if you have one or two people focused simply on doing that and making sure that you adapt the documentation to reflect what it is that you do in a relatively straightforward SMB, so up to several hundred employees. As you get over that and you have more divisions and departments, it gets more complex, and it can take weeks. It can take for organizations with thousands or tens of thousands of employees, it can take months to get the documentation clear. How do the new rules relate to DORA? That is a very good question. So for those of you who don't know it, DORA is the Digital Operational Resilience Act. It is a European Union law that requires all companies that are licensed in the EU to deliver financial services and their third-party ICT suppliers to put in place a very specific set of requirements around governance, risk management, and compliance, around cyber incident reporting, and around testing for security. They are very substantial, and the reality, I think, is that if you are in a position where you're in compliant with DORA, all you then need to do is make sure you can meet the reporting requirements, in other words, the inline XBRL and form requirements of the SEC regs, but you will have in place all of the processes that you need to demonstrate compliance. Are there similar platforms to CyberComply, but specifically for NIST in the US? So yeah, CyberComply deals with NIST in the US. It has all of the frameworks, so ISO, NIST, whatever it is that you require. So you can do a risk assessment that follows NIST's guidance, that draws on one of the NIST set of controls as you see appropriate. They're all there in the US. So it's designed as a global platform. As a supplier to a US listed company, which could have a material impact on listed company, should a cybersecurity breach occur, where does this leave the supplier in terms of reporting via the listed company? Well, that's going to be typically a matter of contractual agreement, firstly, between the listed company and the supplier. We would recommend that your supplier is under a strict obligation to report all breaches, not just material breaches in their view, but material breaches in your view, and probably less than material breaches in your view, in something less than the 4 days that you have to report material breaches to the SEC. So we would typically recommend that contractually you require significant suppliers to be able to report breaches to you within 24 to 48 hours. 48 hours is the GDPR reporting requirement, for instance, so it's not that strange in many cases, and that puts you in a position, therefore, to review and understand the materiality and how it impacts your own determination of materiality and whether you should report it or not. You need to also be in a position where you can audit your material suppliers to make sure that their processes will enable them to report to you in that kind of time frame, because again, you don't want to find out that they can't after it hasn't happened. So in that case, ladies and gentlemen, I hope it has been a useful webinar. We have a series of webinars around the SEC regulations and different aspects of compliance coming up over the course of the next few months. Please do feel free to take advantage of those. The range of options, you can log on to that through any one of our websites, through itgovernanceUSA.com. All of the information is available in the US, but you can also get them through our EU and UK websites. It's all pretty much exactly the same brand, and our services are global in nature. So the quick answer to the final question is auditing cloud service providers, should there be a breach, is again something you would want to do. Negotiating appropriate contracts with cloud service providers can be difficult because it kind of depends on their scale and their level of operation. You might look at the cybersecurity frameworks that they have in place. You might look for their SOC 2 report, for instance. There are a number of things you might look at in terms of your cloud providers to make sure that they are going to be able to report to you in time for you to manage your reporting requirements. Ladies and gentlemen, I hope it's been a useful webinar. Thank you all for joining us today. Again, apologies that William Gamble couldn't be here, and I hope you all have a successful rest of the morning and a successful last afternoon of November. Thank you. Bye-bye.